All right, we are recording. Good morning, everyone. It is, believe it or not, Thursday, November 18th, 2021. And this is a public deliberation of the Baltimore County Board of Appeals in case number 20-224A in the matter of Cornelius and David Helfrich, the legal owner, and Dominion Properties, the contract purchaser for 16 Locust Drive in the first councilmanic district. And it was an appeal of an April 19th, 21 opinion and order of the ALJ denying a petition for variances of side yards, rear yards, lot width, and lot area for a property in the Catonsville area. There were, Mr. Helfrich was represented by counsel, and there were a number of neighbors who appeared in opposition. Everyone filed memoranda on the schedule we had agreed on. And I have some thoughts, but I'm going to ask you for yours first, Mr. Evans.
Okay, well, thank you for that. Well, as I found the memoranda of counsel and protestants to be useful and engaging and well written, informative. So as I see the situation, there are two broad areas to cover. The first is probably the easiest, actually, is whether a variance is warranted under our traditional Cromwell v. Ward standards. And the first requirement of a Cromwell v. Ward variance is that the property be unique. And that's typically understood to be in terms of size, shape, topography, some other natural feature of the land. And in this instance, I think it's conceded by everyone that there's nothing that's unique in that regard, as the word unique is understood under Cromwell. So Mr. Helfrich has argued that the uniqueness derives from the fact that there is this what amounts to prohibitive zoning, and that leaves this to be the only undeveloped lot in the entire development, and the only lot, and the lot can't be developed, I think is pretty clear, can't be developed with a structure at this point. And so the argument is that is unique. I think that's, frankly, it's creative but wrong. Every single variance arises in a situation where there's limiting zoning. So if the fact that there was limiting zoning meant that the property was unique, then of course the exception would swallow the rule, and there would be no real requirement of uniqueness, since, well, as I said, every conceivable variance case has to do with zoning that's perceived to be too restrictive. So, so on the question of Cromwell, for me anyway, it's a fairly easy determination that a variance is not warranted here, would not be lawful. There's a question, I mean, if we were to get beyond uniqueness, there's a question about hardship. And for Cromwell purposes, the question of hardship is in this particular case for me rather thorny. And so I'm not really in a position to make a strong contingent ruling in the event that uniqueness was determined, that it was determined to be unique. But I think the uniqueness question is so strong and so overpowering and so overwhelming that I can't imagine how it could ever be upset, frankly. So that's my position on issue number one, which is under Cromwell v. Ward, the variance should be denied. So the second question, and to some extent, it got sort of blended in and with the Cromwell variance, is the variance that someone is entitled to if there's an administrative taking, or a regulatory, not an administrative, a regulatory taking.
I'm going to interrupt you. I'm sorry.
Okay.
Before we go to that issue,
Yeah.
let's finish with the variance discussion.
Okay.
Ms. Bernardi, are you with us?
I am. I hope you're able to see me because of my bandwidth. They recommend that I turned off my video. Are you able to hear me?
We can hear you perfectly.
Okay, great. So I would concur with Mr. Evans regarding the variance, the uniqueness issue, and the hardship issue, and that it doesn't meet the standards
In
of Cromwell. Yeah.
Okay, let's move on.
All right. Well, the related issue is the question of whether there's a regulatory taking. And a regulatory taking, as I understand it, and of course this is not my strong suit here, but as I understand it, if there is a zoning regulation that's enacted that deprives an owner of all beneficial use of the property, then there can be an administrative taking. It is also my understanding that in order to perfect a claim for an administrative, I'm saying administrative taking, I mean regulatory taking. In order to perfect a claim for a regulatory taking, we are required to make a ruling on that issue. Not exactly sure we're being asked to make such a ruling, but it seems to me that the issue is so completely enmeshed with the overall presentation that it's certainly fair for us to reach that issue and to make a finding there. And you know, what it would mean is that Mr. Helfrich, assuming we make a finding on whether there was a taking, and assuming that, and I think we're entitled to find a variance in order to avoid a taking problem.
I agree.
But I personally am not prepared to do that. And one of the reasons, and this is a very, the record is muddled here to some extent, and in order for there to be a taking, there needs to be a finding that there is no beneficial use at all. It's not simply a hardship as it would be under Cromwell. It has to be an absolute absence of beneficial value. And the Kings have this pending offer for $25,000 to purchase the property. And that's obviously, it's a third of the value that Dominion was willing to offer. But it represents some value, and it represents a value that's not negligible in my estimation. Now, one of the reasons that the record is muddled here is that we don't have any real solid testimony about the valuation of the property. And that's problematic. It is also I have taken the King offer as an offer in good faith, and an offer that continues to be operative. If we were to deny a variance and the Kings were then to withdraw their offer, then over which we would have no control, then there would be no beneficial use to the property and there would be a taking. So, or arguably a taking. So we're kind of in a pickle here.
Indeed, we are.
Yeah.
And I mean, Mrs. King did testify, and she seemed to be a individual of honesty and integrity, and we have no reason to suspect that's not the case. And it would be a very it would be quite distressing, I must say, for us to find that there's no taking because there's this offer, and then to see the offer withdrawn because there's no leverage on the Kings to make the Kings actually follow through with their offer.
I'm not
Just
sure I
off
agree
the
with you, Mr. Evans.
I'm sorry.
I'm going to let you finish, but
I think I'm pretty much done. I guess I would ultimately propose a ruling that is, I'm not sure we've ever done such a thing. I'm not sure it's within our authority, but it would seem, I mean, I would want to make a ruling. I guess I would want to say that there is not, I guess I would want to make a ruling in the alternative, namely that assuming the $25,000 offer remains operative, then I would rule there is no taking. If the $25,000 offer is withdrawn because of a perception that there's increased leverage, then I would rule there was a taking. So that's sort of where I come out. I don't know if that's I don't know how, I'm shrugging here because I just don't know how else to approach this. So that's my view.
Approach it a little differently. I agree with both of you. There's nothing unique about this property. And I'll save my rant for a little later, but I think that I'm looking at Maryland Reclamation Associates, a recent case on inverse condemnation. And it cites a much older case that says regulatory actions that effectively deny an owner the physical or economically viable use of the property. Or conduct that effectively forces an owner to sell can be a regulatory taking. It's exactly what we're looking at. First of all, it can be physical or economically viable use that's denied. It doesn't have to be both. There is no question that the application of the current zoning regulations deny this owner the physical use of this property for a permitted purpose. And I think that looking at the offer from someone outside the property turns the analysis on its head. The analysis is whether the owner can use the property, not whether an adjoiner can use the property, and whether that owner can use it within the four corners of the applicable zoning. And I went through the DR2 regs looking for some use other than a single family house that could be made of this property. And there is absolutely no other principal use that can be made. So if you accept that argument, and you have to look at it not from the neighbor's perspective, but from the property owner's perspective, he is denied physical use of his property or is being forced to sell. And that's the Maryland reclamation case citing College Bowling, citing Amen versus City of Dearborn. I mean, the Maryland case cites a Sixth Circuit case. But those are the elements we're looking at. And I think they're relevant. A variance is a way the courts define a variance as a way to avoid a takings claim. It's a steep burden. Now, that leaves us in the position, as I see it, to deny the variance despite finding there's no use of the property for the owner, and forcing this petitioner to sue the county for a taking. I don't think that's a good result. But I think those are our choices. Now to go on to my rant. And then I'm going to let Ms. Bernard, I'll shut up. The rant is, this was a legally created subdivision before Baltimore County had zoning. Every other lot has been improved with a single family residence. Many of the residences have been the subject of zoning variances to modify them, whatever zone was then applied to the property. And none of these protestants, if they could remember, which affects, in my mind, their credibility as witnesses, really objected to whatever improvements were being made on those lots, not raising any of the so-called environmental arguments that were raised here. I find it audacious on their part to say they should get the benefit of a properly created subdivision, and this property owner shouldn't. And if you go back, and I have gone back to every prior iteration of our zoning regulations, it is clearly intended that properly created subdivisions fall under the small lot table to permit a use of the property. That the county council in its wisdom did not reach further back was either a glaring omission or an assumption that all these uses were grandfathered under these old subdivisions. I can't read their minds. I'm not going there. I think where I come from, the position of the neighbors involves a little chutzpah. And I don't think that arguing that because they're willing to buy it, there's an economic use. To me, that is an impermissible result based on these cases that I've cited. And nothing, well, barely short of extortion by zoning, which is not something I would ever support, whether it be by government or by private parties. So that's my rant. Now I will, having said that, I would grant the variances to avoid a takings claim. And I don't think that we can draft an order in the alternative based on some third-party external situation over which no one has control, and then we would have to supervise it to make sure. I think that's way beyond, we have no equitable jurisdiction. And I think that's what that involves. So that's where I'd come out. So Ms. Bernardi, I'll mute myself if you will.
Just so we're clear, I would probably rule in that way. So just so Ms. Bernardi knows.
You would rule in what way?
I would rule that there is no taking because of the pending offer.
And I would rule that the pending
you would rule that there is
not
yes.
a reasonable economic use by the owner of the property.
Right, for all the reasons you said.
Denied all physical use, which in and of itself, under the cases, is enough to reach a decision to grant the variance.
Right, no,
we
I
disagree. So
yes,
poor Ms.
disagree.
Bernardi is the swing vote.
Right. That's all I wanted to make clear here was that the ball is in her court. Yeah, quite literally.
And my concern was around the taking piece and the fact that there is an offer. I don't feel comfortable making a decision based on a contingent offer. The offer could be reduced. At what point would it not be a good faith offer for the property? My other concern is that I feel the property owner is being penalized because of the timing in which they're choosing to develop their property. If it had been done earlier, then maybe they would not have been challenged because others have had that benefit in this subdivision. And I believe like one of the briefs referenced that if the council had intended for this lot to remain vacant for the benefit of the community, it could have imposed a district overlay in the last couple of zoning maps, and it did not do that to provide for community spaces. And so I feel that there is a constructive taking because the property owner isn't able to use the property for his benefit, and should he have to suffer some type of economic damage or penalty because the property can be made available for the community. If it's for the purpose of the community and not him, then I do see that as a form of taking. So I would like for us to try to find a way to write the opinion so that the variance would be granted because it is a form of taking.
So let me just make a couple points clear here, and I understand reasonable minds can differ, that this is not meant in any way to be, I just want my own views to be clear here. This zoning was done 25 years ago. Mr. Helfrich was not the owner of the property 25 years ago. And this zoning, I think it is impossible to say today what the thought process was of the county council in 1996 or 1995 or whenever it was in the mid-90s that the zoning classification was changed there. So I think that it's not, I don't think we're in a position to sort of second guess presumptively valid legislation that is 2.5 decades old. And I think that Mr. Helfrich has to be understood as having assumed, I mean, the ownership of this parcel has gone through a number of iterations through the testamentary process. Mr. Helfrich has assumed final ownership of this. And I think it has to be understood, it has to be recognized that he took final ownership understanding what the zoning was. So I don't feel, I mean, while it can be said that the neighbors are taking advantage of the zoning, I don't think that, frankly, I don't have any sympathy with Mr. Helfrich. He undertook ownership of the property with the full notion in mind that he had a very, very, very steep cliff to climb in order to obtain any benefit from this property. So I'm not sympathetic to his position for that reason. And ultimately, I mean, it is asserted in the record, and I forget whether there's testimony on this. It's asserted in the brief that the Kings offered to buy this lot at the time they purchased their own lot. And at the time, the parcel was held by a bunch of heirs, and apparently they couldn't reach any agreement, and so that offer was rejected. But I don't view this as I don't view this as extortionate. I don't view this as some sort of unfair, taking unfair advantage of zoning. This is the situation that we find ourselves in. Mr. Helfrich made a business decision to pursue this the way he has. He made a business decision not to sell for $25,000 with the hope and expectation that he could get $75,000. Well, okay, that's a decision he has to live with, in my estimation. So that's sort of how I view the overall gestalt, I guess you could say, of this controversy. It's very unfortunate, and it is thorny and difficult and problematic. I would accept the King offer as I said before, I would accept it as an offer made in good faith that is still standing, still operative, and therefore that means there's a beneficial value, I guess. So anyway, I just want to make that clear so that just for the sort of the sentiment overlay here of the controversy.
That I understand where you're coming from. it personally doesn't change where I am.
Right, and I wasn't trying to, change, I just wanted that stated out loud so that everyone could hear it, that's all.
Ms. Bernardi, are we still in agreement?
I'm still in agreement. I think it's fair to include those comments in the decision so that it's, documented that we did consider that and still reach the conclusion.
All right, then in summary, we are finding that the application of the zoning regs without a variance would be a regulatory taking that would deny all physical use of the property to the owner, and accordingly, to avoid a takings claim, we will grant the variances as requested. Over the objections of Mr. Evans, who believes that the offer by the adjoiner represents a reasonable economic use to the owner of the property.
Right, but we also agree that, so I'll write a dissent on that point, but the three of us do agree that no variance is justified under Cromwell.
Yes.
Correct.
Okay, that would conclude the deliberation in this case. Thank you both, and have a happy Thanksgiving.
Yes,
You too.
same to you, right? Thank you.
Thank you. Bye-bye.
Bye-bye.